see, I'm a consultant. And you'll understand that the first obligation of a consultant is to commit murder by bullet point. I have the impression that lawyers aren't used to slides, and I know that there's some very good reasons for that, some of which are complementary to lawyers and some of which are not complementary to lawyers. But I found out today why lawyers really don't want to use slides. Because these horrible screens get in the way of a fantastic view out there. And I assure you I will have no difficulty whatsoever if you look past me and admire the view. It's a wonderful physical space out there that us guys who are ex-Sydney but for a long time in Canberra do like to get back and see from time to time. Now, what we're here to talk about is cyberspace. And I'm afraid I'm a literalist, and I like to understand what it is I'm talking about and to analyse things. So I want to take us back very quickly and remind us all, which way round do I hold this thing? That way round. Remind us all of what we already know about cyberspace. Because it's depictable with all sorts of lovely graphics. The graphic artists had a field day back in the late 80s onwards with depictions because William Gibson was so graphic in the way in which he described it. And you'll see I'm carefully giving you time to read the slides because I'm not going to read them for you. But Gibson's conception of it long predates the ability of technologists to actually deliver anything approximating what we think cyberspace is. I wish I'd learned to write larger scribbled notes on my overheads, because then I'd be able to see them when I'm standing here. Sorry, I have to have my glasses on and off. Time has wrought its damage. So after about a decade, we did reach the stage where some of the sorts of things that Gibson was imagining in his books, you could place some construction on it as a technologist and say, well, it's a bit of an exaggeration, but actually things are heading a little bit that way. So art predates science and technology quite significantly. Now, there's a lot of different facets to what Gibson dreamt up. And all of these ideas, nobody's ever really tried to take the ideas away from Gibson. He dreamt them all, and we simply run with his images. And the notion of a graphic representation of data, his words that's from the 1984 book, of course talks to us about visualization technologies, as we subsequently called them when we finally managed to come up with some technologies that vaguely match the sorts of ideas that he had. So that's one of the very important things, is that it is a highly visual sensation. The presumption was that we were strongly visual animals and that we would be able to grasp ideas far better if we could visualize them in some ways, and best of all, if something out there could enable that visualization or visualize it for us. But those weren't the only sorts of words that he dreamt up in his amazing typewritten books. He did all of his major works on typewriters, not even on PCs. And this other terminology of a consensual hallucination is absolutely critical to the whole idea, because now we start to bring in the ideas of networking technologies and immersion, the various forms of what we these days call immersive technologies. Those ideas were there from the beginning, before the technologies were there. So what sorts of things does a literalist like me come up with as being the elements that we have to grasp and deal with when we're working out the impacts of cyberspace on technologies, on people, and in this case on the law? Well, the first element is that it's to do with an individual hallucination, but it's also to do with shared hallucinations and surprising degrees of commonality. Equivalent hallucinations across all of us and across many people spread across time and space, unlikely, but a great deal of commonality. And that's been a real surprise, because in our day-to-day activities over the last 30 or so years, we've experienced that surprising commonality. Another is that I had to come up with a word that wasn't space and wasn't location and wasn't place, so I used locus. It's a bailout word. It's a locus of human behaviour. It's where things happen that humans do. And some of those things were intended by designers, and an awful lot of them weren't. And an awful lot of the interesting ones weren't intended by the designers. Some of them are bugs. It simply wasn't meant to work that way, and it's a malfunction from the designer's perspective. But there are also quite a few things which turn out to be useful, turn out to be functionality that's hidden away in there that the designer never dreamt of, but the designer isn't unhappy about, and the designer will subsequently claim. Retrofitting is a big game in the information technology industry. And again, Gibson got there first, because his term, "the street finds its uses for things," absolutely sums up what the arts faculties and media theorists of the world mean by affordances. There's an awful lot of things going on out there that were not intended. But what's it mean now? Because that's all old hat. I could have said everything I've said up to now in the early 90s, mid-90s. In fact, I did say a lot of them because I did most of my writing in this area in the late 1990s. So what's new? What's changed? And does it matter that things have changed? Have things moved on? Do we have new challenges? The call for papers that Chris put out, there's words in there which identify particular kinds of technologies which are modifying the ways in which cyberspace happens. Some of them possibly for the good, and many of them certainly not for the good of humankind. It's also more than a communications infrastructure for humans, and it's not just something carrying data that will eventually help humans hallucinate. It's increasingly for machine-to-machine communications. M2M is becoming a bigger word, and the horribly misconceived idea of the Internet of Things, which is a total furphy. But if you take it apart and put it back together again, there are some very important points around the Internets of Things in this particular corner of cyberspace. And then, of course, cyberspace is rapidly becoming a locus in which machines behave. And that's a big change. That's the stuff of nightmares and a whole pile of other science fiction above and beyond Gibson. Now, having done the quick recap of all the things that represent where we've been and where we think we might be about now with cyberspace, when I sat down to read the papers in the thematic issue, I thought, well, I'm going to have a couple of themes myself. I can't cover the whole field. What sorts of topics do I think might be worth talking about and writing about in the preface? So before I talk briefly about the papers, I'm going to talk to you lengthily about the sorts of things I was thinking about. The first one was, as Justin or Chris, one of the two of you said earlier, was the technology neutrality principle. I've stolen a quote which was the best one I found quickly, which was from Larry Bennett Moses, previously mentioned today, also a colleague and co-author of mine. And that says quite nicely that that's what we're trying to achieve. In order to achieve it, what do? Well, we focus on functions. We don't get down too deeply into the procedural level. Fine. Why are we doing that? There are benefits. There are benefits to people who want to stimulate technologies, the winners, the kinds of people who take advantage of technologies and don't want to be disadvantaged, and then the kinds of people who are at risk of losing also need some kinds of regulatory protections. And if we can fulfill this principle of technology neutrality, won't that be good for all people concerned? And yes, it's a very attractive idea. And I've spent an awful lot of time explaining to people why I don't think it's a workable idea. And the images that I've used in most of my explanations of this have not got to do with the law. They've got to do with nasty things that go bang. Because what we need to think about is, well, what? Big and dangerous things. So mines, I didn't mean mines that go boom, I meant extractive industries and quarries, chemicals factories and power plants are the sorts of things that you need to focus on. And I went looking for those examples. You may or may not have recognised some or all of those. The ones with the really lousy photographs happen to be the oldest ones, top left and bottom right. They're also the two from very much the free world where Freedom of Information Acts exist and all those sorts of things. And do you think it's easy to find photographs of Windscale and 3 Mile Island? No. Have a little think about that one. Chernobyl is quite easy to get photographs of, but that came from one of those horrible countries that was secretive, right? And Fukushima, that really was in the world's gaze. Now, the point about this is technology neutral requirements, functional statements about you must be safe, don't get us very far. There were very, very specific risks that were not handled adequately in each of those 4 instances. And it's very specific kinds of regulatory measures that you need in order to guard against those kinds of accidents and what could have been, in each case, a lot worse than those kinds of accidents. So the key point about technology neutrality is it is extraordinarily difficult, because when you get to really dangerous things, your needs are actually techno-specific, not techno-neutral. You've got to get down to tin tacks. Now, quite clearly, my target zone here is not nuclear power plants, about which I know precious little. My target zone is something different entirely. The basic point is that there are some things that are sufficiently different from all the other things that you've got to tackle them as themselves. It's no good trying to come up with generality when generality won't work. Well, let's run a little test on this, because Chris used the law of the horse, which I didn't pick up until only a few days ago in his foreword to the issue. And in conversation with multiple people, I was delighted to receive feedback from about 8 of the 14 people I sent my paper to, which is a higher batting average than usual, I've got to say. And Graham Greenleaf spent some time reminding me about the law of the horse. It's an important question as to whether there will be insufficient depth of understanding if we simply come up with laws for horses or any other specific thing, rather than building on that wonderful edifice that is the law, or the many kinds of laws. The fact is, horses are different. And I've chosen one particular kind of horse that's particularly different, because Lipizzaner, how many people here have ever seen Lipizzanas at work and play? Absolutely stunning horses. I'm not a horse person, but these things are fantastic. There's an enormous amount of enormous number of regulatory measures involved in training horses like this in Vienna, by the way. So I think it's really important that we do have a deep understanding of not just horses, but even of specific kinds of horses and specific contexts when we're trying to come up with regulatory measures for horses. But it ain't just horses. Cows are different. They have quite different kinds of needs. And I picked on a Swiss cow partly because Braunvieh are really, really pretty when you're walking up there in the Alps, but also because Switzerland has got some of the tightest regulations on cows anywhere in the world. And of course, some animals are laws unto themselves, and that opens up another can of worms. No, don't mix metaphors that badly, Roger. Sorry, that was unplanned, that one. And it's not just those kinds of animals. I picked on 3 animals, all of which are A, domesticated, and B, get eaten. The ones down the bottom right involve a completely different set of regulatory challenges. It's native, it's protected, don't eat it, please don't run over it. So we have to set up quite different kinds of frameworks and understand what it is that we are trying to deal with. You have to treat the thing as itself. The best quote I've ever found to support this in articles and in presentations, it's slightly long, it's on the next slide, but so you'll have to read fast before I take the slide away from you. It also deals in chelonians. Everybody happy with chelonians? How many people know what I'm talking about? Chelonians, chelonians, chelonians. It is in the dictionary. It wasn't just made up by the person who wrote the book that I'm depending upon here. How many people know Terry Pratchett and the Discworld? Terry Pratchett and the Discworld? Come on, you don't have to be embarrassed. Put your hands up. It's credible reading. The Discworld is to fantasy what Douglas Adams is to science fiction. It's spoof, and splendidly done spoofs. It enables him to indulge all of his arts faculty philosophy from his university days and take everybody out at once. And to do that, he had to have a flat Earth, because you can't possibly have a sphere, could you? So the Earth travels along on the back of a giant turtle 10,000 miles long, but it's the last bit that matters. Well, the rest of it is just setting. There is absolutely nothing you can realistically be like except yourself when you are a really big, complicated, specialised thing. The one I used to use back in my systems theory days, a long time ago, was that there is only one actually reliable model of a complex real-world system, and that is the complex real-world system itself. And from a simulation viewpoint and from a variety of different arenas in computer science and information systems, that's a very important insight to always remember. So technology neutrality was one of the things that concerned me as I came to these papers. The other thing that concerned me was technological understanding as demonstrated in the courts. Now, I've got a probably too lengthy section in the paper, which I'm not going to read to you word for word, because it's awfully heavy, from my first experiences in the mid-80s, when I examined the judgments involved in the case of the Wombat ROMs. The case of the Wombat ROMs was the case in which the courts determined in Australia that software was not a proper subject matter for copyright. And this made me very happy, because I thought it was an absolutely stupid idea that copyright, as it exists in the Copyright Act, should apply to software. We obviously needed something very specific. And I've had PhD students who worked on that very topic. I found a whole pile of things in those judgments which were amazing to read. And I've picked out a couple of them. Source programs a forward instruction to the operator. The word operator referred to a human operator of computers in the context. And the other one was source code consisted essentially of instructions to be read and followed by a human reader. I don't know what counsel actually said, and I never went back to the court records to find out what expert evidence was left available to the judges of the High Court by the time it reached them in the third round. But each of those statements is utterly ridiculous. And there's no sensible construction that you can actually place on those words, and they were in the direct line of reasoning of those judges. This was my first introduction. I successfully published this article. I must say I published it in a computer journal, not in a law journal. It's a bit of a worry. Have people worked out what the left side and right side banners are? That clear to you? Well, I did my schooling about there, and you're somewhere, we're currently standing somewhere down around there. So it's the east coast of Australia. What's the other one? Chile. It's Chile. Why have I got Chile and Australia on this slide?
They're on opposing sides of the Pacific.
Yeah, they are on opposing sides of the Pacific, but on this occasion they were joined in something. I've not been able to quickly research whether it's still true, but at the time, these were the only two countries in the world that found that copyright did not subsist in software. Of course, the other trick is that right now there's an awful lot of worry about something that may or may not be on the bottom of the ocean around about here somewhere. Yeah, okay, so Chile and Australia have a number of things in common. But we have got to the World Cup. Chile hasn't. So my first introduction was a worry. What happened after that? Well, I've done something over 20 expert evidence events. Not all of them necessarily before the court, or well, I've probably been in front of courts 7 or 8 of those 20 occasions. And I have been impressed with district court judges and with tribunals, predominantly the AAT, something else, and patents examiners on multiple occasions, because quite a number of them were patents cases, because they have worked at it. They have asked questions, and they've demonstrated in their judgments that they'd listened to and tried to understand what the experts were trying to convey to them. The opposite is true in the superior courts, both Supreme and Federal. I have been very disappointed with my experiences. They are laid out in the preface. They're the sorts of things that are somewhat pejorative, and therefore one chooses one's words extremely carefully, which I can do in a preface, and I can't do standing up here extemporising. But I have had very disappointing experiences as an expert witness in front of the superior courts in Australia. It has been apparent to me that there's been not only misapprehensions and ambiguities, but there have been misapprehensions and ambiguities that have been significant to the reasoning of the judges and the outcomes of the cases. And I think it's important that judges come to understand that their credibility is not always strong when it comes to their demonstration of technical understanding in the cases that they're dealing with, at least in my fields. There's a couple of constructive things that I can suggest from my limited experience of these matters, and this is not academic research, this is experience as a paid hand. One is that amicus curiae submissions are almost always dismissed in Australian courts, and I think that's unfortunate because they sometimes have more than a little to offer. That's said more as an advocate. The second one is that I find it blithering that the courts continue to accept that technical evidence and expert evidence comes through the filter of the parties to the case. Now, a good expert works extremely hard not to be unduly biased by the perceived interests of the person who's paying the bills. That's a given, because otherwise you're going to be torn limb from limb in court. It's not just a question of integrity and principle, it's a question of practicality. But that's not how the game is played out in court. And once again, in the preface, I've got a little bit of gory detail explaining why I use the word character assassination as being the primary purpose that barristers have in mind when they cross-examine an expert witness. Because if they can assassinate the character of the expert, then the content doesn't matter and they don't have to get down to tin tacks and fight over the real technical issues. And the judges appear to be quite happy with that idea because they are ex-barristers and because it's awfully hard work to understand the gobbledygook that some of us experts write. So I think that getting experts dealt with directly by the courts would be a heck of an improvement and would lead to fewer misapprehensions and ambiguities. Let's pick one particular area that is directly relevant to the final couple of arguments I'm going to run. We used to have really simple ways of developing software. Back in my day, when I was a programmer and a project manager, we used algorithmic or procedural languages. We were quite explicitly dealing with a solution. We knew what the problem was that we were trying to solve. When the fabled rule-based expert systems, thank you Patrick, came along some years later, these don't actually deal in solutions or in problems. They define something about a problem domain, is the way certainly many of us describe it. So the idea of a problem at any given time may be difficult to work out when you're using an expert system. It may be possible, it may be impossible, it's most likely somewhere in between the two. But wait, there's more. A later generation, which is the current vogue, is what I call empirical. Empirical techniques is my description of it. It's been my description of it for 30 years, but it is dealing with such things as neural nets, but machine learning and whatever AI is, AI/ML approaches are in this same cluster. And these deal in heaps of data. That's why I use the word empirical for them. You basically get a shovel and you just pile a whole pile of data into something that has a very small amount of preforming to it. It's not totally without some logical structure, but it is largely without structure and it is largely data. What problem? What solution? What problem domain? There isn't any in the software, and you can't, I better be careful what word I use here. You can't infer a problem, a solution, or a problem domain, or perhaps to say it even more safely, you can't reliably and non-contestably infer a problem, a solution, or a problem domain when you are dealing with sixth generation software. That is a serious challenge to humankind, and it's a serious challenge to the courts. One of the challenges, I had to decide which of the various challenges I was going to highlight, so I had to pause and remember where I got to in my preparations. One of the challenges is in the copyright space. Okay, we're stuck with this, we were talking about horses before, weren't we? With this camel that is the Copyright Act applied to software. Everybody knows that a camel is a horse designed by a committee, right? Okay, so that's the current definition in the Act. It's a set of statements or instructions in order to bring about a certain result. Third generation, no problem. Fifth generation, small amount of concentration required. Yes, I'd be very surprised if that wasn't held to be proper subject matter. Sixth generation, go for it, all you sophists out there, barristers out there. Do what you can to try and make that fit to that. I think is an extremely challenging thing. It doesn't greatly worry me. It will make quite a few lawyers quite a lot of money someday, but that's not my business. I'm much more concerned with law as a weapon of policy than I am with law as a means for lawyers to make money and for problems to be solved between two large corporations. So go for it, fellas. This will be good fun. But there are other problems that arise from the 6th generation, because where we get to is that if you don't understand what the problem is, if you don't understand what the solution is you're trying to gain, if you don't have a proper mapping of the problem domain you're studying, how the heck do you come up with a rationale that explains how you inferred, how you reached your conclusion? You cannot get rational explanations out of 6th generation, and in many cases you can't even get rational explanations out of a 5th generation. A tool, software developed using 5th generation tools cannot give you the explanations you need. So what does that mean about decision transparency? How do you explain to the welfare recipient that they breached the law because, when you cannot come up with a rational statement after the because? That's the situation we're in. The reason I've given that specific example down the bottom of the Centrelink fiasco only a few months ago. And also the way in which we've sold our credit data to an American corporation, which is now bringing in something that we did without for many, many years, which was these kinds of approaches taken to credit data in order to come up with scores for people. Horrible direction we're going in, and the effect of that is, of course, that we destroy accountability. So I think we've got some serious problems in this. I'd love to spend some time on the abandonment of reason and the deification of data, but that's somehow another story, taking things a little bit too far. So, with that background, I then sat down and read the papers, hoping I'd find something in the papers that would give me a hook. And if not, I was going to have to change my direction a little bit, wasn't I? It's a very interesting set of 6 papers. They're fairly diverse. There's a little bit of clustering, but they cover quite a bit of territory. David Lindsay from Monash University, a co-author of Graham's and well known to me through the Privacy Foundation in particular, was looking at injunctions to block access. It's a very careful, being David, and very readable study of this area. And it did indeed give me the hook that I was looking for and worried I wouldn't get, because he noted a particular apparent misunderstanding, which was a conflation between 2 ideas. Now that conflation between 2 ideas, if you can remember back a little while ago, ASIC were inane and implemented some blocking, and as a result the world tumbled to the fact that Section 313 of the Telecommunications Act has been abused for quite a few years by quite a few agencies. I don't know how many people of you play in this game, but that was a very specific instance of exactly what David's drawing out here, and something that I spent rather too much time, or wasted too much time, trying to convey to a Senate committee a couple of years ago. So there's a lot in David's paper that's of interest and also fits into some of the themes that I was interested in. These 2 papers form a bit of a pair in that both of them focus on e-money. I'm mindful of the fact, Catherine, that A, you're here, and B, I haven't actually put a square brackets behind your paper. I put one behind the pair of papers. I don't know Catherine, but I know she's here somewhere. And I think she might be the only author who is here, so from this set, so I should recognise you. These were very interesting in looking at e-money, and the important thing to me, given the lenses that I was looking through, is that part of the problem with the e-money world at the moment, and trying to work out what the law does with it, what regulation more generally does with e-money, is that it's being treated as something that it isn't, because that's what the law does. The law deals in certain things. It has particular definitions already in place. That's what technology neutrality means. Obviously, everything will be fitted into the existing basket of concepts, won't it? And it doesn't fit. These things are different and they need to be approached differently. Otherwise, you will have some serious policy problems arising. So both of those are interesting papers and well worth a visit. This was a quite different paper, and one dealing with a contentious and worrisome topic, which is a current theme in Australian society, of domestic abuse, and looking at technology facilitating domestic abuse. The thing that, and it's really short when I trivialise the important topic by saying, and the reason I'm interested in it is, but that's what I'm going to do. The reason that I was interested in it was that it challenged me, because mostly I argue for more specificity. You must deal with the thing as it really is, and don't pretend it's something else and do everything by metaphor. Don't apply old ideas, apply new ideas to the new things that are out there. But here, my actual stance is a little bit different, because if we had a generic right of action in the privacy field, it would have given us mechanisms already to address the revenge porn issue in particular. So I actually found myself arguing against myself in reading this paper. It's always good when that kind of thing happens. The last couple of papers also form a pair in that they are dealing with the effects of technology during trials, a couple of rather different cuts to the problem areas. And once again, the particularities of technology are really important in these analyses. So I found a lot of value in this, in all 6 of these papers. Oops. A couple of thoughts that I wanted to throw in at the end, drawing on these themes. The first one is that I was proposing and have proposed in the preface that we've got to be careful, we've got to have a principle in trying to apply this technology neutrality. And that was the principle that I was suggesting. You've got to get the scope right, otherwise you are going to really muck this up. And of course, my proposition is tested by that 4th paper on the revenge porn topic in particular. The second cluster of things that arise from this in my mind are that we thought about cyberspace as a blizzard of data. That's how it's always been projected in all the sci-fi books and all the sci-fi films. But it's a lot more than that. I've given some examples already, but is it becoming a protected enclave for devices? We now have devices that act directly on the world. And is intelligence emergent out there in cyberspace? If so, that is going to be changing our conceptions of ourselves. I thought, how can I do this graphically to try to make it a little bit clearer or more alive? Back when I was young, I joined the computer industry in 1967. Seems like a long time ago because it is. I wrote my first program 50 years ago last May. That's scary. That was what it was all about. It was a computer industry, and that modelled the world that I was playing in. It wasn't until, depending on how you look at it, the 80s, that communications really became a big part of what we have subsequently called the IT industry. The marriage, as we called it, of the computing and communications industries changed the game dramatically. It's kept changing. It's really important that we understand that is not the end game. It's moved on. Robotics is a problematic suite of different technologies, but it has all of the elements of it have in common that there is something within the system that can have an effect on the real world, a physical effect on the real world. Now, while ever it is the dispensing of banknotes, we do still have ATMs, they haven't all been closed down yet, and I actually used one today. When that machine pokes things out, when the machine up top draws my card into the belly of the machine and then returns it later on a little tractor, each of those is a robotic action. Those ones don't scare us much, do they? Some of the other things that robots do, particularly as we let them loose in the real world, definitely do, or should, worry us. Computers have migrated from playing around with carburetors and fuel injection. They aren't just calculating, given the wear and tear and the temperature of the vehicle at the current time and 14 other factors, how much of what should I poke inside that chamber. It's moved way beyond that. Now we are talking about autonomous vehicles, and Volvo hopes that Uber is serious about that order. You had heard about that order, hadn't you? $1 billion worth of cars on order as driverless cars to get rid of Uber's troublesome drivers. Those kinds of effectors we've got to be really concerned about, and all of this is within the context of computing and communications. It's inherent in the way in which robotics is working. It's all tied in. And intellectics may or may not exist, but will they tell us when they invent it? The robots, I mean. We have people out there who are saying that reason is on its deathbed. We don't need reason anymore. We can delegate it all to the machine. We can do it all by correlation and let our wonderful calculations do it for us. That kind of delegation gets really interesting. It's been done in sci-fi. Arthur C. Clarke did it to death. But people aren't taking any notice of Arthur C. Clarke anymore. So I think we've got to watch ourselves where humankind's concerned. That's maybe not your interest, certainly not my interest. I'm dead before any of this stuff really starts to cut. But I've got children and I've got grandchildren. And I really do wonder what it is that we have been sleepwalking our way into right now, and which you lot are going to be instrumental in paving the legal way to enable, to ensure that it actually comes about so that the large companies that want to do these things get to do them. You're the people doing it. I'm really quite concerned about how that's going to work, and I do suggest to you and your successors that thematic issue is needed not only on the specifics, and you've got a very good one here on the specifics. We need a thematic issue also on the quite general issues of where the heck is this technology going, and what impact will that be having on humankind, and through it the law. Thank you very much.